Hey, Paul here again, and in this video, we're going to take a look at the do-it-yourself estate planning documents versus the hiring an estate lawyer to put together an estate legal program. And I'm going to look at it from a different perspective. So what initiated this video was a comment from one of my YouTube channel viewers. Yesterday in one of the comments to a video, Vic asked, could you comment on online legal do-it-yourself software such as Nolo or LegalZoom? By the way, excellent information on naming the trust, which is a different video that Vic watched. Okay, Vic, so, really, here's the deal. And I'm gonna focus on the do-it-yourself stuff. I'm gonna focus on LegalZoom, and I know that there's many do-it-yourself estate legal document businesses out there, but it certainly seems to me that of the maybe 20 or so businesses that are out there in the do-it-yourself estate legal document arena, probably LegalZoom is the elephant in the room. It's the one whose commercials you always see on the television. Their stuff is all over the internet. So I'm going to focus on that, but really my response is appropriate not only for LegalZoom, but for any of those, kind of do-it-yourself estate legal document preparation software businesses. Okay, now I will start by saying, and this is where I want to be different than what you may hear or read elsewhere. You can go on Google and search this question, and you'll see probably at least 1,000 blog posts, articles, all written by lawyers. Virtually everyone says, don't do the do-it-yourself stuff. And quite frankly, one of the, they all say the obvious, or some of the obvious reasons, and some of the logical reasons why you should use lawyers to put together an estate legal program versus do-it-yourself stuff. Everyone has some form of, if you do it through the do-it-yourself stuff, you're not going to have somebody counsel you through your intimate decisions. If you use a lawyer, they can give you tax guidance. They can give you long-term care guidance if that's appropriate on protecting your assets. They can help you coordinate probate versus non-probate assets. They can help you through special needs planning or unique family circumstances. And all of those arguments as to why you should use an estate lawyer instead of do-it-yourself estate legal documents have significant merit. The only thing though is that lawyers have the lawyers who are giving you this advice, they have a financial interest in you not using do-it-yourself software or forms, because the consumers out there who use the do-it-yourself forms, they're not going to see the lawyer. So the lawyers really have a pretty strong financial interest in persuading you to not go the do-it-yourself route and go the lawyer route. And I get that, and that that all makes sense. But I'm also here to say, and here's where really I may go off the beaten path a little bit. I feel like not all, but many consumers are ignoring that advice from lawyers. And here's why I think they're ignoring that advice from lawyers, because now I'm going to kind of talk about the LegalZoom route. I know that 2 years ago in 2018, LegalZoom, their business, they raised some funds, and based on the amount of funds that they raised, their business, the LegalZoom business, was valued at the time, 2 years ago, as having a value of $2 billion. And that's a really big business. And if LegalZoom is worth $2 billion, it means there's a lot of consumers that are using LegalZoom to get their estate legal documents prepared. Yes, LegalZoom offers other things. I think they have, in the business formation and business consulting and all of that. There's estate planning isn't the only component of LegalZoom, but it's a significant one. So you got a $2 billion business. That means a lot of consumers are using those services. And so that to me means like a lot of consumers are hearing lawyers say don't do it, but they're doing it anyway. So from my perspective on this video, what I want to go over is, if you're going to do it, if you're one of those people that says, I don't care what the lawyer's saying, I'm not going to go to a lawyer, the lawyer's saying it because the lawyer wants me to go to the lawyer, I'm going this route. If you're considering, using LegalZoom or another do-it-yourself, these are the things that may be safe, you may need to watch out for. So I want to look at it from that perspective. All right. When we talk about the do-it-yourself stuff, I really have to break it down into two components on the do-it-yourself and using a lawyer. The first component I'm going to talk about is the meeting the formality requirements. The second part that I'm going to talk about is the substantive part of creating legal documents, and is the wording correct? Does it do what it's intended to do? I think there's a lot of people, the consumers, when they want to go the do-it-yourself route, they focus on, well, I can make a valid will. What they're saying is, I can meet these formality requirements. But when you deal with lawyers, the lawyer's like, well, of course we're going to meet the formality requirements, but that's a piece of cake. The tricky part is having the substantive components all correct. So I cringe a little bit when somebody asks me, can I just make a valid will that meets the formality requirements by doing X? And the answer is, of course, yes, because the consumers focus on the formality requirements, where that's the easy one, where people and lawyers and anybody who engages in something like this really should be focusing on the substantive components of everything. So I'm going to assume, for purposes of our discussion here, that the do-it-yourself stuff is going to meet the formality requirements. It's going to have the language that makes it valid. It's going to have the proper notary and witness combination, and all that's going to meet all of the appropriate formality and validity requirements of the state. Although I've seen a number of do-it-yourself companies that can't even get the formality stuff right. I think LegalZoom's going to probably get it right. They're good enough to at least meet the formality requirements. But to me, that's just a given. It's the substantive stuff that we got to get right. All right, so now let's take a look at that. And I almost hate to piece by piece this thing, because that's not what estate planning is. But when we're talking about do-it-yourself stuff, it seems like people want to talk about it piece by piece. So I'm going to talk about it piece by piece. I'm going to go from kind of simple to more complex. Virtually everyone who creates an estate planning legal program considers getting a living will done. That's this statement of your wishes regarding life support machines if you're in some kind of profound comatose state with no chance of recovery, and the machines are serving only to artificially prolong the dying process. I would say if you did that through a do-it-yourself program, the risks of screwing it up are not that great. Most states use a fairly standard form. I'm sure LegalZoom and other do-it-yourselfers use some version of the fairly standard form. So not as much of a risk to use the kind of do-it-yourselfer stuff for a living will declaration. The next thing I'm going to go to is the power of attorney stuff. And typically you have two. You have a power of attorney. This is who can make your decisions for you if you're incapacitated. And you do one for financial, business, real estate reasons. And then you do another for medical, healthcare reasons, or decisions that may need to be made if you can't make them for yourself. I got to admit, that's fairly standard. Occasionally we get a client who needs some type of customization for that. And yes, many people do limited powers of attorney that only allow certain transactions to be done at certain times. Maybe you're going out of the country and your house needs to be sold, so you want to appoint somebody to sell your house for you for just that limited transaction for that limited period of time. But most of the power of attorney stuff is fairly straightforward, fairly customized. I hate to use the word boilerplate, but quite frankly, most of it is. It tends to be kind of a quick afterthought in the estate planning process for most lawyers. So those, you're not taking a significant risk by doing that through some type of do-it-yourself stuff, as long as the do-it-yourself creator takes all of your appropriate state considerations, into the creation of their, do-it-yourself form. But now as we start getting into, let's call it your will, here's where, even if it's what you consider to be a simple will, some people call the office or talk to me, Paul, I just want to get a simple will. Quite frankly, I think what they're saying is, Paul, I just want to get a cheap will. But nonetheless, even if your circumstances are simple, you still may need someone to counsel you through certain decisions. Let me give you an example. Let's say Loverboy is, it's time. He's 60 years old, and it's time for him to write his will. He's heard enough about needing a will. It's time to do it. He wants to go to LegalZoom to do it. So, or any other type of do-it-yourself software. And Loverboy is married. Loverboy has kids, and so maybe the software questionnaire says, all right, Loverboy, do you want to have a will? Loverboy says, checks, yes. Loverboy, are you married? Loverboy checks, yes. Loverboy, do you want to leave your estate to your wife? Loverboy checks, yes. And then Loverboy's kind of impressed because it even asks him some further questions. Loverboy, if your wife dies before you, do you want to leave your estate to your kids? Loverboy checks yes. And so now he feels, wow, I've taken care of my wife, I've taken care of my kids, this is great. He goes on and answers more questions about who's his executor gonna be. He checks the boxes that says his wife will be his executor, his oldest child will be his alternate executor. He's feeling good. Now, maybe that will do it, but there's nobody there to ask Loverboy the question that maybe I would ask at that times. And I might say, Loverboy, I realize your wife is your second wife, or maybe it's his first wife, and maybe the two kids together, Loverboy and his wife have 3 kids together. And I might say, Loverboy, I know you just told me you want to leave your estate to your wife, you want to take care of your wife, and we're about to move on, and I'm sure that's what you want to do, and we're going to do that. But let me just ask you one question. So, is it okay with you, Loverboy, that you do leave ownership and leave everything to your wife? Giving your wife the ability, if she gets demented or if she gets remarried or goes into another relationship, that because you left everything to her, she could, with one signature after you die, could leave the whole shebang to people other than your children. Or Loverboy, would you want to make all of this, available for your wife, but make sure that when your wife dies, what's left or what you left her goes back to your kids? And then Loverboy might say, you know what, that's a good point. Let's talk about what some of those protections for my children might be so that I can take care of my wife and also know that my children are protected. So that's just, as we go through the estate planning process, there's maybe a dozen of those kinds of discussions that need to take place, and you're just not going to get that in the check the box, do it yourself estate planning software. So there's that. So that's where I get a little nervous and sometimes a lot nervous when I hear people doing their will through the do-it-yourself stuff, even if they can meet the formality requirements. Hey, big deal. Is substantively, are they getting everything right? And then I'm going to the next piece of, LegalZoom and others, they offer you the ability to create trusts for yourself and for the benefit of others. And so when I see people try to do the do-it-yourself stuff and they want to create a trust, boy, that makes the coronavirus pandemic uncut hair on the back of my neck stand up. Because when you do the do-it-yourself stuff to create a trust, you're not only needing to have all of those critical conversations about that you'd have if that I just talked about when someone creates a will, but in addition to all of those conversations that are necessary when you create a trust, there's a bunch of other technical stuff that has to be done, such as not only creating the trust, but transferring assets to your trust, transferring your real estate or your home to your trust, transferring business interests to your trust, transferring investments to your trust. And then with the trust, there's the preparation and the recordation in land records of certain trust certificates or trust extracts. And so with living wills, powers of attorney, wills, you're not having to do any of that extra stuff. You just make sure it's done right, you sign it, and it's done. But when you create trusts, not only can trust be complicated, but there's a number of additional pieces that can and do get missed if you try to do this yourself. So there you have it. Kind of depends on what you're going to do. Now, I will tell you, quite frankly, if you're going to use the lawyer to get all of the important discussions that you need to have with a lawyer, but you also want to make sure you have all your power of attorney and living will stuff done, you might as well get the lawyer to do that as well, because they'll do that as part of an overall estate planning program that they'll put together for you. Okay, so real important also in this area that you do hit the thumbs up button. If you haven't subscribed, make sure you hit the red subscribe button and the notification bell. That way you don't miss anything, and you'll tell YouTube, hey, why don't you show Paul's videos to a few more folks? And then if you want to share this video maybe with somebody else who's considering the do-it-yourself stuff, that might help as well. Okay, we'll see you next time. I'm Paul Rabelais.